All right, cases. 24 CR 1041, obstruction of retaliation, and 24 CR 1818, state jail felony will be legal possession of a controlled substance. No priors. And go ahead.
So, Judge,
You're moving, I think.
well,
No, actually, the court's the movement. You set conditions of his bond on November 11th, ordering, he was in custody with a no bond. You set his bond at 50,000 with a drug patch, GPS device, home confinement. You gave him exceptions for work, seeing his attorney, and medical needs.
Okay. I think that was on September.
September 11th. And then
You know,
you got an email. Yes, sir.
hold up. Do you know you said November?
I'm sorry. I apologize.
he's been
No,
waiting.
sorry.
We all looked at each other, but we let you,
We let you go with it.
Okay.
we let you go for it just to see
I
how
appreciate
down
it.
that road you were going to
Appreciate
take.
it.
But nonetheless,
September 11th.
today is what?
Judge, in the wake of that, Mr. Ham and I were notified that a Beaumont police officer has reached out to Ford and suggested that Mr. Harvey was not in compliance with his GPS device. I have since had a very, very stern conversation with him about the terms and parameters of his bond and how the GPS device works and how he needs to comply with it. And that as a practical matter, Judge, I went back and reviewed the transcript and the court told him not to be ambling about and told him to be at home or work for his lawyer's office or medical appointments, things of that nature, but didn't specify home confinement. Mr. Harvey did not get any kind of written bond conditions when he bonded out, but I have now told him very thoroughly that that is exactly what that means, that he is supposed to be at home other than being at work or being in my office or in court or medical appointments.
Make copies for everybody of this. This is the order that the memorandum that was entered on 9/11. Was it 9/11?
It was, Judge.
He wasn't providing a copy of that.
No, but I articulated them on the record at the time.
I know.
But it's like we always do. We make memos and
Sure.
try to get them out to people, but it's on the record. Well,
I
for
know.
folks to see and be aware of.
I filed a written objection relating to the obtaining of this evidence because I have a very
Obtaining of the what evidence? What are you talking?
a police officer being able to log in and just see where he is into some system and just tap into the GPS system and track his whereabouts whenever he wants to. And as it turns out, it's the police officer who is the complainant in the retaliation case, which I have a real problem with.
So what are you asking?
I'm asking for the court to disregard that information and evidence. It hadn't even been presented yet, but to disregard any information and evidence that was obtained solely through.
All I want is, right now, all I want is to get the conditions of bond done before something bad happens on my watch.
Right.
That's all.
We-
Somebody, because shame on someone else, not me.
I agree.
Yeah. And there's another one for here. And yeah, people are keeping an eye on it. There's no reason they shouldn't be. And if I'm alerted to a condition of bond, any citizen, anybody, help me police my job because I'm not out watching everybody. I can't do that. Is there anything about those bond conditions we set that you didn't understand? I'm talking to you. Is there anything about those bond conditions I said that you are confused over? What do you say?
He said it was a couple things, but Judge, we've clarified them now. He's not confused anymore. I have talked to him. He's not confused anymore. And I think he understands
Yeah.
exactly how
I
he's supposed
expect
to.
the court's orders to be followed, or else somebody gets in trouble. It's a court order. You have lost some of your freedoms. That's just what happens when you're charged with a crime sometimes.
Yes, sir.
And what this court can do is, if I'm not satisfied with what you're doing, I can revoke your bond and you can sit it out in jail until we can get this thing disposed of. Which happens from time to time.
I'll remind the court that this was at a no bond status before he left. And I agree with Officer Jackson that all this conduct that was brought to the court's attention is the fact that this young man is not taking any of this seriously at all. One of the conditions that, when he left the courtroom, it was really clear that what his lawyer advocated for him was that he'd be allowed to take care of work, see his attorney, and take care of his medical needs. And instead, 2 days later, he spends 3 hours wandering around one of the local parks. There's nothing about that can be argued is in any fashion whatsoever associated with those terms. And he does that right on the eve, right after you instruct him not to do that. And this, saying I didn't have this memorandum, that's an interesting legal argument, but the fact is he stood right where he's standing right there and didn't understand what you told him. How are we going to have any guarantees going to understand this? His lawyer might, but that sure doesn't connotate to the defendant.
There's a motion to revoke probation in a misdemeanor court?
Yes,
Is
sir.
that right?
Yes, sir. I brought that up whenever, because I was pointing out to the court that he can't seem to follow rules.
All right. These are also over a year old.
Yes,
What
sir.
are we doing?
It's on the trial docket right now for a date in December.
Okay. We're going on the 3rd-degree felony?
Probably, Judge, just because it carries more weight.
Well, that's what normally is done, but I just.
Well, it's going to turn on where I'm at with evidence and all as far as.
Okay, get ready for trial then.
Yes, sir.
You got my attention, which you don't want. Anything else? Who else? Anybody else?